What's up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. Sorry for the delay. I was doing other stuff. So I'm here with my friend Schnitzel Ninja. She's back. On
Hey.
Sunday, Brad and I were, going and recapping the video that David had put out and about this case, and I was just like, this is just like not the same. Like, not that Brad, you know what I mean, just that you weren't
Yeah.
there. Not that Brad was, Brad did
No,
great.
I wish
Brad had to help me out a lot with that one because I was at work all day, and he, like sent me a voice note basically explaining it to me, and I was like, I still don't get it, Brad. Please help.
Just explain it, please.
I was so tired. Please, Brad, please help me.
God, I think back to the Baldoni video you did too. That was like you were on for like 6 hours and 40 minutes around.
That was a while ago now. It's been a few weeks, but
Well, yeah,
that,
but still, I mean, that was like a long ass. That was kudos.
Yeah, I mean, people. I forgot to do my super chat. Go, hang on, 1 second. Well, people are like mean. Outside of this little niche audience, people are mean. So like, I have been getting some comments that are basically like telling me my videos are shit. I'm just like, you guys really don't appreciate. Like, I get off work at 5, and I'm over here working on something so that I can go on stream at 8 or whatever it was. And then I did that, and then I went downstairs and I made dinner and ate as fast as I could, and then I came back up here to do this. So I'm like, people really just like.
Wait, aren't you just reading? Aren't you just reading the filing?
What filing? This one?
Like the gag order. Didn't you just read that?
Oh no, I read the like 4 or 5 of the filings, but
Yeah.
I mean, it was like not that much subjective opinion going into it. I was like, listen, my mind is open as far as the legal arguments go. Like, as far as the gag order goes, it was a lot more complex than I realized, obviously, because I'm not a lawyer. So I was like, there's a little gray area here. And I know people aren't going to like that, but, I mean, everybody has very strong opinions about this to the point that they're very critical of anyone who doesn't agree with their opinions. And my opinion was literally just like, I'm reading this page. Like, what is the big deal? And I said, like, my opinions have leaned heavily towards Justin in that case up to this point. But, like, I have an open mind, and I recognize that I don't know these people. And, like, I don't know. Still, people don't like that. It's like you better say what they want you to say, or else.
Yeah, I mean, you can't make everybody happy, and you're allowed to have a fucking opinion. You're allowed to. You're allowed to read it and say, "This is what I think about what I just read."
Right. So it's just been hard. I mean, branching off into other things. Obviously, I like to do it, but since I have a small audience, a large percent of that being critical is going to be difficult. So that was, it is what it is. So.
Well, hey, maybe they'll just hate watch and they'll still give you numbers. Also, we will be having, at some point, for a little bit, a special guest.
Oh? When?
Mar?
Oh, is he coming?
Yeah.
Okay. I know he's busy tonight, so I wasn't sure if he was going to come on or not.
He's getting his girls down right now, and then he hopes to hop on.
Well, the last I heard from him, he was sending me pictures of himself from, I don't know when this is from, but he said hip hop photos, and then
he sent me the same thing.
Yeah, and there was like old pictures of. I'm gonna get in trouble for doing this, aren't I? But I'm gonna share this with.
Yeah, you got to.
I don't know if you can see this, but here's one of them. He looks like he's a good looking dude.
Right? I know he's hot. Everybody knows he's hot.
There's Omar in his hip hop days. I'm sure he'll show like the rest of them. You can't really see it very well because I'm holding it up to the.
It's hard. You should send it to yourself on Discord and display it.
Oh yeah, I guess I could do that. I don't care enough.
Did he tell you what well, not that one in particular, but the other ones with the cars? Did he tell you what the?
Oh yeah, I have those. From? Yeah, I have those. No, he didn't tell me what they were from because I didn't ask. But
I was like, "Where were these taken?" And he said it was a music video shoot for. I'm trying to remember what music video he said.
Not one of Diddy's, I hope.
Not one of Diddy's, but I think it was someone who knew Diddy.
Oh god! I mean, doesn't everyone in Hollywood? I guess kind of.
Right.
All right, fine. Hold on. Let me. All right, hang on. I'm gonna send this and this.
Oh, No More Shopping Sprees by Rough Ends.
No more shopping. Oh, okay.
Yeah, it's the music video.
Well, if he wants to show it to us, we'll let him do that. I'm not gonna bring it up right now, but
also I found out this was right after he got fired as a youth pastor.
Well, see, I don't ask questions, and that's a problem.
It wasn't his fault. He got fired for like standing up for morals. Anyway, he can tell more of the story if he wants.
I don't really care about why. I just care that it happened.
He refused to do something like terrible that they were asking him to do.
Okay. Well, I won't. I won't bring it up right now. Oh, there he is. Okay.
There it is.
That's it, everyone. That's the stream. That's the stream.
Oh my god.
All right.
Love it.
Lisa B, thank you for the $5 for a new red turtleneck. Thank you very much. I appreciate that. I'll have to get a new one, yeah. All right. So this was the response brief filed on Laura's behalf by David, and he released it today as a gift, I guess, to JFC. I did not watch David's video today. I asked some people what it was about, but I was busy, obviously, doing the other stream I did before this one, so I didn't get a chance to even look at it. Did you watch it?
I sure did.
All right.
Baby Jingy watching every single one. He got mad at me the other day. Yeah.
What did you do?
Well, I called him out on some misstatements that he's made, and he muted me on his channel, and then he did no comments on this video today.
Oh, you got the block?
I did.
I really want to know what you said to earn that. I feel like I saw it and I don't remember what it was.
I have it somewhere. It was talking about how the only reason Matt, Mike, Greg were brought into the case, the paternity case, is because they were mentioned by name in the motion in limine. Had they not been mentioned there, Clayton's side would not have had the option to bring them up, to mention them, to have them be potential witnesses for the case. It was a huge fuck up on his part, and he's going to say it wasn't, and it was. And I wanted Laura to know that.
Like she listens to anything we say.
Like I mean, she's ever watched any of these videos.
No, she watches them for sure. For sure.
Yeah, I get he's the only lawyer who has supported her and stuck by her. Like, I don't blame her for staying with him. I don't. He's probably been like a knight in shining armor to her. For different reasons. But anyway, I said that, and then I mentioned which I cannot talk more about at this time, how she stalked a victim in New York City at their place of employment.
And that's one of the ones that we've already established as a victim, or
I can't say because I have permission just to share.
Fair enough.
This. So yeah, anyway.
And that was within the last, however long it's been since the trial?
It was in September.
So it's only been a few months. Okay.
And it was like almost to the day, 3 months after the trial.
Okay. So that's creepy as hell.
Yeah, especially when she doesn't even live there.
Nope.
Especially when this person's the address for their employment was not easily discoverable online. Like, there was digging done to find this information.
So she dug through and found out that person's employer and then went there? Or?
Yeah, well, they were contacted.
Okay.
Is what I can say for now.
Gotcha. All right. Jane Jones says, is when she was at Barry's boot camp in NYC.
Yes, it is. Yes, it was. With Jan, perhaps?
I thought that was a joke, but all right.
No. It's when she was visiting her sister.
Yeah.
In New York, and apparently went to Barry's.
Okay. All right then. Anyways, about this video, I had a couple people tell me the highlights. I guess the lawyer was talking about his family life and his history, which I won't get into too much details of his younger family life. If you want to learn about that, go to his channel. I'm not a dick, so I'm not going to recap everything he said about his childhood and rip off his views, because I've never done that, despite his accusations and threats towards me. So if you want to hear about, his childhood, go listen to him talk about it.
I want to say that what he tried to compare what he has done to what Laura has done.
How many men have impregnated him?
Oh, well, haven't you heard about that one paternity case where someone claimed he was the father?
Yeah, I heard about it. It was not the same. But yeah.
Not the same, but obviously he can't see that because he doesn't understand reason, in
Yeah.
my opinion. Anyway, yeah, it's just not comparable. It's not comparable.
Yeah.
Whatever reality he wants to live in to try to represent his client. I mean, this happens with lawyers all the time, right? Like, well, they say there are three sides to every story, but whoever, like, OJ Simpson's lawyers, like, knew he fucking done it. They knew he did it, and they still had to represent
You think
him.
he did it?
What? You know, I mean, they still had to, like, we know this, like, you have to defend your person, even, well, ethically, I guess, whatever rules you have to follow, but
Mhm.
you know what I'm saying. So, like, I get he's doing his job, but it's like he just has taken it, like, way past the line of, like, what he needs to do, in my opinion.
Yeah, that's true. That's true. Sorry, I was just writing a note to somebody in the chat there.
Mhm.
So he also talked about his legal history there. Let's see, what else did they send me? Just like a couple of arrests, I think. Spent the night in jail, blah blah blah.
Yeah, he was just naming a couple things that he'd gotten arrested for when he was young.
Yeah. Huh. Okay. I guess he's trying to like relate his personal experience, like you said, to Laura, but
Yeah, exactly.
like,
Saying that everybody makes mistakes. There's no perfect person out there.
yeah,
And
but
that
people
Laura,
they don't double down on those mistakes and bring it to court. So it's
exactly, they learn from their mistakes. They say, "Oh wow, when I told this guy I was pregnant with his twins in 2014, he didn't believe me. He called me out on my shit. He got his lawyer who was pregnant to make me go to see her OBGYN, and then she would take me seriously. I dropped the case and then I claimed a miscarriage. Maybe I shouldn't do that again." Well, no. Fucking bitch did it again.
yeah,
And again. And again.
only a few times. It's fine. So everybody asks us, we need more Omar pics in the background of this. You're gonna have to ask Omar.
You're gonna get one of a pipe.
One of a not to me, no.
What? No, like literally, there's a picture of a pipe in here. It's a famous piece of art.
That could mean anything to me.
Well, wait till you see it.
Okay, so I heard he didn't talk. He usually talks through his arguments and stuff in his videos. I heard he did not talk much about his actual brief in this one. I don't know if that's correct or not, but yeah, okay. Okay, well, I guess we'll see for ourselves. We're gonna kind of skip over a lot of the legalese tonight because Omar's not gonna be able to be with us for long if he does end up joining. And we'll go over the legal cases and stuff that's cited in here more some other time, probably tomorrow or something. But we'll just skip through it tonight and see what's being said, and we won't, go through the case law too much or anything like that. Hang on 1 sec. Okay, that is not what I was trying to open. All right. Also, guys, not to disappoint you, if you saw the Twitter posts, there's nothing about galactic level mistakes in here. I figured that I was being trolled back for trolling them, but maybe it had nothing to do with me, and that was just really his draft. I don't know, but I kind of am disappointed because it would have been really funny to see that in a real legal filing.
So we know he has two versions of this. He had a version, what if it wasn't approved, and if it was approved, and then I think he also had a version of if his talk with Marcus had gone poorly.
I see.
In his opinion. Well, so I think the galactic proportions thing would have been in there.
Yeah. Okay. So let's see. How far does this preface go? Up to the discussion. Okay. You want to read the first part for me? I'll scroll through. You want to read this part up to like page 6, and then I'll take over from there.
Here we go. All right. Preface. Like any appeal, the primary focus should be: did the lower court commit any reversible legal errors? Sometimes the answer to that question depends heavily on a factual issue, and sometimes not. This case involves complicated facts, and without doubt, the record reflects numerous factual errors committed by the trial court. Indeed, the very first fact the trial court found, that Laura commenced this action on May 20th, 2023, was wrong. Footnote 1. The case was filed on August 1st, 2023, not May 20th, 2023. But the trial court's error. There we go. Minor mistakes as to the filing date is not why we are here. Laura's opening brief made that clear. Quote, plentiful and egregious factual mistakes notwithstanding, factual errors are not the primary focus here. End quote. Opening brief at 2. That statement was and is still true. At the same time, it is critically important for this court to receive accurate information about the facts to help guide the court's legal analysis. Unfortunately, Clayton's answering brief contains inaccurate statements about the record, some of which are highly inflammatory. Laura's reply thus begins with some clarifying points to avoid confusion about the record. Oh, yes, please. Let's clarify. Laura's opening brief explained the trial court made multiple errors of fact. Quote, many of the trial court's findings are either directly contrary to the admitted evidence or supported by no evidence of any kind, end quote. Despite this warning, which was not news to either side, in his discussion of the facts, Clayton repeats numerous findings made by the trial court as if they are accurate and supported by the record, even when they are plainly are not. A few of the more serious examples. Laura admitted sending Clayton a sonogram video she copied from YouTube. Clayton claims Laura admitted, quote, to providing Clayton a 7-year-old sonogram video of twins she obtained online months earlier, end quote. As support, Clayton cites the under-advisement ruling, and sure enough, it does contain that finding. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. The UAR states Laura admitted this during her deposition. The UAR cites trial exhibit A28 as support, but that exhibit was not admitted in evidence and it was not Laura's deposition. Worse yet, in her deposition, which was received in evidence as trial exhibit B49, Laura did not admit to sending Clayton a sonogram video because she was lying from YouTube. On the contrary, Laura flatly denied this allegation. So the question, you sent account that you attach this ultrasound image, would you agree you sent it then, correct? Answer from Laura, I'm positive I did not send this ultrasound video. Exhibit B49, Laura gave exactly the same response at trial. So Clayton, here's my 100 billion% real ultrasound video. Do you recognize that? Answer, it's not an email that I sent, but I've seen it since. Oh, it must have been Jan who sent it then, and then Laura saw it later. In short, I can't hear you.
That's because I keep muting myself.
Okay. I kept thinking like I feel like she's saying stuff, but then I can't hear her, and then
I have been saying stuff. Nothing of consequence though, so there's that.
Okay, you're probably like, why is she just talking over me? All right.
Well, you didn't say anything to something I said like a minute or two ago, and I was like, oh. Anyways, go ahead. And
I was thinking, gosh, she's being quiet.
No, I wasn't. Just, for my own benefit, I guess.
Oh, okay. In short, they're not a shred of evidence. Oh, talk about typos, Mr. Fuckface. Okay. In short, they're not a shred of evidence in the record to show Laura admitted sending Clayton a sonogram video copied from YouTube. It is false to say Laura admitted this in her deposition. On the contrary, Laura denied this in her deposition, and she denied it again at trial. Here's very bad lie number 2. Laura knew she was not pregnant when she filed this action because she did not allege sexual intercourse occurred in her original petition. One of Clayton's central themes is that Laura knew she was not pregnant because only oral sex occurred. Clayton's brief repeats that story. On May 20th, 2023, Laura performed oral sex on Clayton. In a footnote to that sentence, Clayton further suggests Laura alleged there was non-consensual sexual intercourse, but this was not alleged initially in the court filings. It was not alleged until 2024. Laura's original petition exclusively disproves this.
Conclusively, ma'am.
Conclusively disproves.
Say the wrong word with your whole chest. That's worse than me speaking out loud with the
troll me. Okay, so footnote 2, there was a separate dispute as to whether the intercourse was consensual, but Clayton does not frame the issue as limited to that question. Moreover, the alleged lack of consent was not new and was not raised only after Clayton sought sanctions. It was described in correspondence between the parties shortly after the case began. And then there's the email that he links there. So this has sexual intercourse checked. Parties A and B were not living together, but had sexual intercourse. Blah, blah, blah.
Hold on.
Do you want me to read that?
This is what this was. Hang on. Exhibit list cover sheet says just it's not the actual. That's unfortunate because I would really like to see all the exhibits.
Yeah.
No, I have to have a case center log on for this link. Come on, David. Give me your log on. Give me your log on like Lauren gives me her whatever password for what was it? What was it again where she sends the password to all the media?
Yeah, exactly.
I don't remember. What was the name of that clinic? Shit.
Oh,
No, it wasn't Barrow. No, I'm just kidding. That's the brain injury thing.
was it One Medical?
Yeah, I think it was. I thought it was one something. Anyways, back here.
One lie after
by
another.
the way, did you get that?
What was it?
All right, go.
Oh yeah, maybe it was Banner Health. They're saying Banner Health.
Oh yeah, Banner Health. It was Banner Health. Yep. Go ahead.
Egregious lie number 3. Multiple other men believed Laura fabricated pregnancies and doctored medical records. Correct. And that did happen.
Wait,
Okay.
where are we looking at?
Top of page 5.
Great. What?
Multiple other men believed Laura.
Multiple other men. Oh, the actual. Okay, I see. Well, you said egregious lie number 3, and I was like,
sorry.
Like,
where does it say that?
I was trying to find it. Oh god.
Okay. One of the most harrowing examples of an inflammatory yet baseless fact offered by Clayton is this. This was the 4th time Laura had tested positive for pregnancy in her lifetime. All prior alleged fathers believed she fabricated the pregnancy and doctored medical records. To support the shocking fact, Clayton quotes from the UAR. And once again, page 4 contains those exact findings. What admitted trial evidence supported that finding? Absolutely nothing. Due to the extreme brevity of the June 10th evidentiary hearing, no other prior alleged fathers testified, just Clayton, nor was their testimony offered by other means, stipulation or deposition. In fact, the only attempt to support this allegation was a question which led to an objection that was sustained by the, what is he called, Judge Mata? Like, very unfair, biased judge, sustained one of his objections. So biased. Question. And they also believe that you doctored medical records, right? Mr. Gingras. Objection. Foundation. The court sustained. The above examples are only a few instances of several inaccurate statements Clayton made about the record below. To be clear about the actual facts in the record, Laura did not admit sending someone else's sonogram video copied from YouTube in her deposition or anywhere else. Laura did not file this paternity action without alleging sexual intercourse occurred or alleging that only oral sex occurred. And there was zero admitted trial evidence to show either that Laura fabricated a pregnancy in the past or that other putative fathers believed she doctored medical records. Of course, Laura recognizes the trial court found the above points were true, and she understands factual findings normally receive deference, except where, as here, they are clearly erroneous. Gibbs versus Gibbs. It suffices to say the trial court's factual errors are extensive, and Clayton's discussion of the facts is misleading at best. But there is good news. Resolving this appeal does not require reversing the trial court's factual errors. As such, this brief does not identify or explain every factual error, because factual disputes have no effect on this appeal, except I spent the first fucking 6 pages talking about factual error, even though they don't matter. This court should not linger on them. It should just be aware that Laura firmly disputes the accuracy of the record, as discussed in Clayton's brief.
Where
Do you want me to keep going?
Yeah.
Right there, top of 7.
Yeah, go ahead a little bit longer. I'm trying to do something real quick.
Okay. 2, discussion. Turning to the merits, we begin with a subtle theme in Clayton's brief. While he never specifically says so, his position rests heavily on the old maxim, quote, equity will not suffer a wrong without a remedy, end quote. Clayton argues Laura's position is inequitable because, in his view, the core issue is whether a person may tamper with evidence and lie under oath and then opt out of the litigation consequence free. If ever there was a histrionic argument invoking the all flexible power of equity, that's it. But Clayton is wrong to suggest that Laura will walk away consequence free if she prevails here. Putting aside the devastating reputational, emotional, and financial harm she has already suffered, give me a fucking break. In addition to the nearly $150,000 judgment, it takes a while for it to refocus on the screen. The trial court also referred Laura for investigation and potential criminal prosecution. The Maricopa County attorney has not yet charged Laura with any crime, despite making public statements about her investigation. It is impossible to know why charges have not been filed. Whatever the reason, Clayton is wrong to say if Laura prevails, she will walk away without any consequences. Hardly.
What?
Clayton also ignores another point. Even assuming this court orders the paternity case dismissed, that does not mean Clayton has no remedy. Indeed, while Clayton argues Arizona's Civil Rule 11 and Family Law Rule 26 are materially different, i.e., less protective of litigants like Laura, than the federal version on which they are based, the comments to the 1993 revision of Fed R Civ P11 are clear. The rule's safe harbor does not provide immunity from civil liability arising from litigation abuse. Yeah, so just make Clayton go buy a civil attorney, pay for a civil attorney, and litigate the shit out of that for a couple years. He has options. It should be noted that Rule 11 does not preclude a party from initiating an independent action for malicious prosecution or abuse of process. If Laura wins this appeal, Clayton could potentially still bring a separate civil action against her. While this option exists, it may be a bad idea. Clayton's trial counsel used a similar approach in an earlier case and lost. See ROA 90. Nevertheless, if Clayton wants more relief, other options exist. And what's ROA 90?
Let's find out. It's the request for judicial notice.
Okay.
RA 93 is the order entered by the courts. Petitioner's request for judicial notice is granted.
Okay.
Nothing too
Nevertheless, if Clayton wants more relief, other options exist. This leads to a final point that is extremely important. It is clear what really happened in the case below. Clayton tried to litigate civil tort counterclaims against Laura in family court, but he forgot one key thing. The family court has no subject matter jurisdiction over tort claims. Bam.
I see lots of people talk about Omar. I sent Omar the link in an email. Guys, you want me to let Omar in? Send lots of bacons in the chat. Otherwise, I'm not letting him in.
Come on in, Omar.
All right. This is so because although Arizona family courts sit in equity, their jurisdiction is strictly defined and constrained by statute. Despite the application of equitable standards in a dissolution proceeding, it remains a statutory action, and the trial court has only such jurisdiction as is granted by statute. Thus, Title 25 defines the boundaries of a dissolution court's jurisdiction, and the court may not exceed its jurisdiction even when exercising its equitable powers. All right. If Weaver v. Weaver, that's... I mean,
Weaver, I barely know her.
It's family court. It gives the family court limited jurisdiction to establish maternity or paternity. Once Laura informed the family court on December 28th that she was no longer pregnant, there was no paternity to establish. Nothing in Title 25 authorized the family court to exceed its limited jurisdiction by granting Clayton limitless, freewheeling power to endlessly investigate and litigate civil tort claims in family court. Those claims belong in civil, not family court. In any case, Clayton is simply wrong to suggest Laura winning this appeal means she walks away consequence-free. I haven't seen an explanation for that.
He's saying that Clayton can take her to civil court and that she might be charges might be brought by Rachel Mitchell against her.
Oh yeah.
It's like Clayton has options.
Somebody says looks like someone is raiding you. Who's raiding me?
Bacon. Who's the bacon person?
No, that's me. I told them to put bacon if they want me to let Omar in. But Omar's not here yet, guys. All right, hang on. Let's see. Where did we get to? The consequence-free thing? And you were saying, what about that? Because I was distracted. Bacon.
I was distracted by bacon.
Me too.
No, he was just saying that, like, it's just like, yes, Clayton has the option of, like, one time I got a speeding ticket, and
No.
I did. It was actually like right after I got robbed at gunpoint, and I completely
Were you speeding away from the robber? Because I feel like that's
no, it was maybe it was the day before I got robbed, and then I got robbed, and I completely forgot whatever it was. I completely forgot about the speeding ticket because of getting robbed, and I had just moved, and it was like this thing that looked like it was like a highway, but the speed was 35, even though it was like a highway thing. Anyway, when I went to court, the police officer was willing to give me a ticket for like going like 5 and under, like 1 to 4 miles per hour over the speed limit, and I was actually like 24. And then the prosecutor was like, or the who does it for the state? Is that the prosecutor, right?
Yeah.
She was basically like, no, like we're prosecuting this to the fullest extent, and blah blah blah. So then they said, well, you have the option to go to like a hearing and try to fight for this. And I was like, well, like, no, that's not really an option, because like what evidence I'm just gonna go and say that, and of course they're gonna believe a police officer over me. And then they were like, well, it's an option, you have an option. And so anyway, it made me think of this, where it's not really a realistic option. Like he could, but it's obviously, it's like, it would cost so much money. He would have to have her in his life for another couple of years. It's just like so stupid to even suggest.
Yeah. Right.
Thanks for going on that tangent with me.
You're welcome. Haley, well, it's like he's just trying to push the stuff onto civil, so Laura gets out of paying this fine, and then thinks Clayton won't pursue civil remedies. He might not. I mean, he might not want to deal with that, to be honest. But we'll see. We'll see. Because this is like a bunch of bullshit that she's going to keep getting away with if she's not punished or something in some way, you know?
Yeah, and I think it also depends on what she does from this point on. Does she drop it? Does she stop talking about him?
Well, she's continuing to go after Greg, so I'm going to say no. She doesn't stop anything.
Right. And then at that point, I mean, I can see him, and he still has he still has tea that he has not released on Laura. Let's keep that in mind. Does she really want that to come out? Is the question.
She'll just say it was Greg. So do we have any idea about what's going on with the Greg case? I haven't checked in a while if there's any sort of date for a hearing or anything.
I don't know what I can.
I hear you.
I don't think there's a date yet, though.
Okay, I got you. I have not asked or looked because I've just been so busy. So, all right. Okay. Laura's brief presented 5 questions for review. Clayton's response breaks each into multiple subparts. Well, this reply will follow a similar format. You really wasted some of your 7,000, never mind, words on that, but Laura was sanctioned under Rule 26, but even if she was not, the safe harbor still protects her. Clayton begins by challenging the centerpiece of Laura's argument, i.e. that Clayton did not follow the requirements of Family Law Rule 26, so the award of sanctions under Rule 26 was improper. Clayton says that this argument is misplaced because he thinks the trial court did not sanction Laura under Rule 26. Therefore, Clayton contends Laura's arguments about Rule 26 are moot. I hate that word, man. Moot.
Moot. A moot poont.
Ew. Clayton's rebuttal echoes Renee Magritte. Is it Renee Magritte? How do you...
Magritte, yeah.
Okay. I was like, how do you say that? Renee Magritte. Famous surrealist painting, The Treachery of Images. To make a point, Magritte absurdly painted a smoking pipe, then captioned the painting with the famous line, "Oh no, you do it."
Ceci n'est pas une pipe.
I'm sorry.
This is not a pipe.
Could you say that one more time?
Ceci n'est pas une pipe.
Same.
Je suis la jeune fille.
Okay. I can't stand that. All right. Oh, no, I'm just kidding. Okay. With the caption that reads, "This is not a pipe, get it?" Much like Magritte's painting, Clayton's Rule 26 argument is equal parts surreal and absurd.
This filing is
That's how I feel about that. Yes, sweet, pissed off. Je suis a clown. That's the only word I know. Je suis.
Je suis. Je suis me.
Je m'appelle.
Lauren.
Je m'appelle. Throwing shit at the wall.
Je m'appelle Schnitzel Ninja.
All right. Of course, the trial court sanctioned Laura under Rule 26, putting aside the fact that Clayton filed only a Rule 26 motion for sanctions and no other motions for fees or sanctions. The UAR specifically cited Rule 26 as a proper basis for sanctions. Furthermore, the June 10th hearing was set in response to Clayton's Rule 26 motion. That's not true, is it? Was set in response to Clayton's Rule 26 motion. That was withdrawn before the hearing, yes?
Mm-hmm.
So what the fuck are you talking about? Okay. All right. Oh, there's Omar. Hey.
Hey.
Hello there, family.
Hey, do you like
peep?
Do you like my new profile pic?
Oh my god. Oh. Yeah, so I got this. I have the Google Photos thing, and then it randomly says, "Hey, here's pictures from like 20 years ago." It's like, "Oh, look at that!" And then I sent it to Lauren, and I sent it to Schnitzel.
That was a mistake.
Well, it could have been worse, I guess.
I texted back, I think, and I said, I want to see your old yearbook photos. That's the real stuff.
Yeah, and then I looked for them. I don't have them on my phone. I gotta go through my.
Oh well, no, I wouldn't expect you to unless you're like really narcissistic. But you know,
no, I'm not gonna send all of my like 8th grade, whatever.
I'm not talking to you until you send them.
I sent him one of me around the
kid.
same age.
Oh yeah. Wait, how old were you in that photo again?
I figured out I must have been like 20 years old.
Okay.
Sub 21, because those cars in that other photos I sent you were in a music video, and that video was released in 2000. So I must have been like 19, 20-ish, right around that range. Good times.
Cool. I haven't watched your music video yet. I'm sorry.
It's not my music video.
It might as well be.
The car's on there.
Yeah.
All right. Where are we at here? The Rule 26 was the only pending...
man. Is there anything good
in this thing? It seems pretty tame so far.
It's full of shit.
So,
in my opinion,
you and I were going to be dual streaming this at some point.
We're skipping over the legalese. I'm not going to do all that tonight.
I've decided when I read this, I'm not going to like prep it. I'm not. I know what his argument is. I know what their argument is. He's replying to their reply. And so I'm just going to read it and react in real time. I watched his video, though, where he was wanting Laura and what's his name? Clayton. Laura and Clayton to move on. And he kept on talking about the velvet dress or whatever he was saying, the maroon dress. He wants to get back to smiling, and he wants to have a beer with Clayton. But he's like, well, Clayton, kick my ass. He literally said that.
Are you? No, I haven't watched that. Are you out of your fucking mind, man?
That's what he was saying. And then I don't know, Laura was talking about some stuff. I kind of tuned that part out.
That was the last video, not the one today.
The one where they imitated you? Was that where he did an Omar impression?
Oh,
recently.
did he do it again?
No,
in that last one, not the one today, but
you were in the chat the other night when me and Brad were talking about that one, and then I pulled up the clip where he was like imitating you, and I was like, I want Omar to come on here and do a David impression.
I'm gonna save that for our dual stream.
Okay, I gave him a 5 out of 10. It wasn't a total fail, but it wasn't great.
All he does is talking vocal fry. That's not even my voice, man. He just like literally takes out all of the music in his voice and just like, my name is Omar.
That's perfect. That's a perfect Jingris impression of him doing Omar.
Now he thinks I am.
Oh my gosh.
Also, you sound sick. Are you sick or tired? Or sick and tired?
I think my throat is tired. I've had like this dry cough I've been fighting off for like 2 weeks. My throat is exhausted, and not for. Never mind. I said that. Nobody.
Yeah, you already said it. It's too late. It's
Never
too late
mind.
now.
My throat's just so tired. It's been such a busy week.
It's out there forever now. Okay. Oh man. All right. Let's see. Where were we at? Okay. The Rule 26 motion was the only pending motion in which sanctions or fees were requested. As Laura has noted many times, the rules of family law procedure require parties seeking relief to bring a motion for relief. Expressing a desire for fees in a response to a petition or verbally at a hearing is not sufficient. A motion is required, yet the only fee-seeking motion Clayton ever filed sought fees only based on Rule 26. Since Clayton brought a motion for sanctions under Rule 26 and did not bring any motions for fees under any other authority, the trial court must have granted relief under Rule 26 based on the court's own authority.
Precisely. Wait, is he making this argument? Because if he is, then I believe that's a misstatement of the facts. I think we should decipher whether or not he's committed fraud by that paragraph. Because that was not what he brought relief under. It was under two other statutes. I forget what they were, 12 something and the other one, whatever the other one was.
Yeah, that's pretty much what's happening here. Yeah. But he said it with an example of a fancy French thing, so it counts.
Oh, I heard that one. And oh my God. I was going to say, you wanted a Schnitzel to repeat that thing, and she said in French, it was like as you were furiously masturbating to her.
My hands are here, mister.
But where are your feet?
Ew. Explain how you do. Never mind.
I just saw you do it. You'll have.
Just we confused. Anyways. Since Clayton brought a motion for sanctions under Rule 26, did I read that already? Blah, 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 blah. Okay. Must have granted under the court's own authority. Precisely, the U.S. states it did. Okay. The power is there by rule and can be used by the court when necessary and appropriate. Okay. A painting of a pipe is still a pipe. Didn't we see that already? Did he repeat himself? I feel like he did. Hang on.
What is he on about with this pipe thing, man? What are we doing?
I don't know. It's maybe
the point of this analogy?
Yeah. There's a Marguerite painted pipe. Okay. Okay. Read it again. Read it again. Read it again.
Ceci n'est pas une pipe.
Okay. A painting of a pipe is still a pipe. Yeah. Okay. Still a pipe, no matter the caption. And an order granting sanctions under Rule 26 is a Rule 26 order. That's a false equivalency, I believe. But
yeah, I want to save that for our thing.
Yeah. Let's do
analysis of that. But I mean, his insistence that because one time they brought a Rule 26 motion after he requested relief in two other sanctions, and therefore it somehow obliterates the rest of the family code over there in Arizona. I've never been able to connect the logical dots with that one. So we're just going to have a difference of opinion. I did watch his video. It was the only one I've ever watched.
Really?
And other than clips of when he was like trying to impersonate me. But he said that this is like he's done debating with people because it's like Trump and Hillary. They're like, you're either.
Where have I heard that before though? Like,
oh, I know. He says it all the time, right?
Yeah.
It's not like that because half people were in agreement with Trump and half the people were in agreement with, I don't know, Hillary, Biden, whatever. In this case, it appears like 98% of the people are not his way, not going his way. And
90 is a little low ball in it.
Where's Brad when I need him to give his spreadsheet?
I don't know where Brad is tonight.
Oh, I know. Oh, not Brad. Bruce. Bruce
is out of town.
Yeah. I don't know about Bruce.
Yeah.
He was happy texting me this morning.
Okay, so I got a message that says relief was granted under ARS 25-324, 25-415, and Rule 49. So are we just ignoring that? Is that what's happening here?
Oh, I blanked out what you said.
Oh, so he's saying the Rule 26, it's still a Rule 26 ruling, but the relief was actually granted under, hang on, what was it?
25.
ARS 25, 324, ARS 25-415, and Rule 49.
I think it goes on to say, like, well, it doesn't matter which one. Like, then why do you bring it up?
I'm honestly confused by his logic and how he's arguing.
Yeah.
Like, it's a creative argument. It just doesn't work. It just, the puzzle pieces don't fit. Not for me. They don't fit for me. I don't know. Maybe I'm the dumbass. He said that I'm the idiot. Maybe he's right.
He's
We're
in
all-
love with you. Don't even
We're all
listen to that.
idiots.
No, he's in love with Omar.
He's got
We
a
all know
boner
that.
for you and Woodnick, which I don't blame him, but come on.
Woodnick will clap those cheeks one more time.
His mouth cheeks destroy him in the courtroom.
And wear that
Gregory.
Hey, how about I'm in my new home studio, and I'm testing out my brand new mic. How's it sound?
It sounds good.
Yep.
I like that one. I like it. I like these settings.
Yeah, it sounds nice. It sounds
Sounds better
warm.
than the impression of you I heard the other night. So.
Well, I watched a YouTube video about how to set up your microphone on the Rodecaster.
Oh, damn. I have my new microphone. I don't have my lights set up yet though, so it's still not perfect. So.
What kind of microphone are you running nowadays?
It's a Shure, and then there's a box over there. It's a
SMB, whatever?
SM7B, yeah.
Man, that's the one I got. And then I got
Yeah.
this other one, ECM30, that I'm about to try out over the weekend. I heard it's better for people that don't have high voices. We'll see.
That might work for me.
Oh my god.
Ah!
Nice. I sound like a pedophile every time you do that.
Should I do it lower? Oh my god.
I don't know if that's better or worse. But it's less it's less never mind. Never
I think
mind.
she left. She left us. All right. Anyways, speaking of pipes,
I'm trying to get Lauren demonetized off of this one.
yeah, demonetize me, but you might get me to leave. All right. Let's see. The court included detailed findings about Rule 26 issue in the UAR, but the court ultimately only awarded attorneys' fees and costs under Title 25 statutes based on relative financial positions, unreasonable positions, and discovery and disclosure violations. Okay, we'll get into that later. Or did it, ignoring that the court did rely on Rule 26, even if it did not? Wait, what? Okay. There are three other significant problems with Clayton's argument. Okay, sure. First, contrary to Clayton's suggestion, the court declined to award fees based on relative financial positions. On that, the UAR was unambiguous. The court finds there is no substantial disparity of financial resources between the parties. Second, Clayton is correct. The court based its decision in part on unreasonable positions. But what unreasonable position did Laura... Well, really. What unreasonable position did Laura take?
The knees.
We're going to need more than 7,000 characters, folks. All right. Again, or words, I guess. Again, the UAR leaves no doubt. The court further finds that petitioner acted unreasonably in the litigation. Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit.
Yes.
Okay, problem with that. So, per the court, Laura's unreasonable position was the same Rule 26 violation raised in raised in Clayton's Rule 26 motion. This time, the painting and the caption say the same thing. This is a pipe.
Can I just make a point? So he's saying that the merits of the initial claims for sanctions mirrored the merits of the claim of the Rule 26 claim, and therefore Rule 26 should prevail. Irrespective of when they were brought in time, show me any case that says that matters, which is the problem. Like there's been no legal authority to support this idea that Rule 26 somehow cancels out everything simply because it seems to mirror Federal Rule 11. I don't know, but
yeah, that's what I hear a lot. So
the problem with Gingras is he's a good talker, he's a smooth talker, he's a used car salesman. He gets you to believe and say any bullshit that he wants, and he'll go off and you'll start believing it. And because he's an attorney, he'll start talking like this and he'll speak very confidently. I don't think you've ever heard him speak about his motions or his legal position with anything other than coming from a position of confidence. That's a classic used car salesman tactic. They taught me that when I was selling Kirby's door to door in Columbus, Ohio.
wait, what's Kirby's?
Vacuums. What's
I need a Kirby.
It's like the video game.
Sell me a Kirby.
Kirby.
It's not the video game.
No, but I'm saying in the video game he can vacuum things up. Like he sucks things up and then he takes on their shape.
Gross.
But it's a play on the vacuums.
I used to be a used cars. Well, no, I used to be a Kirby vacuum cleaner salesman, door to door, and that's what they say. Speak from a position of strength. Always be confident. Whatever you say, whatever he says, these things. There's just not much merit to anything that he says. They don't connect the logical dots.
Mm-hmm.
And so what I would have needed for this argument to work is any case. I think he tried to cite a Kentucky case, and he got mad at me and he said, yes, I'm citing a Kentucky case, Omar. It's like, what? I didn't say anything. And then he said I claimed he was being unethical. And then I said, no, he's being something else. And then Lawrence said I was going to get canceled. So
yeah.
I just said, do what you want, but hey, I mean, I'm not saying
it really depends on your audience. It depends on your audience there.
Yeah. Well, never mind. I'm just saying, I needed a case that said that if you raise a Rule 26 motion, it cancels out all other pending litigation with respect to sanctions. Absent something like that, I don't see how you could cancel them out if those motions were pending, and they'd been pending since August of 2023. And that was a point that was raised in the brief response that Marcus wrote. It's the point that I had raised long before, and when I did my initial video, I raised that point with Jingers himself. And I told him, okay, but like there was other motions pending. There was other sanctions pending under other rules. What about those? And I literally asked him, so are you saying that Rule 26 cancels out those other motions? And he said, yes. I was like, okay. And then I was looking for a singular case that said that that's what it did.
And you couldn't find one.
Maybe that Kentucky case says it. I don't know. Problem is, Kentucky has nothing to do with Arizona's family court ruls. Unless
not
he's
true, sir. There is a KFC in Arizona as well. So
for sure.
Just saying.
Imagine so. Unless
basically all intermixed.
He's basically trying to say that other states have done it, so we should do it too. That's not binding. It's to be persuasive as to his argument. But never mind. I'll save that for our thing.
Also, the chat is going off about.
Well, yeah, I was going to ask. I have two important questions here. Erica P wants to know if Kirby is an MLM.
Yes, I think it was an MLM.
And you joined an MLM, sir?
I was a college student. I was like 20 years old. I was needing a job, and they sold me on hopes and dreams. And like, well, shit, I ain't doing nothing else, man. Fucking, I'll go sell Kirby's.
You should have gone and been on like reality TV or something.
Well, back then it wasn't as big of a thing. You know?
Yeah. I don't know. I would make it a thing right now. I'd find that and be like, this is Omar on TV 20 years ago. You know. Anyways, the second question I have is the Kirby's mattress demo was barf. What was the Kirby's mattress demo?
Oh, well, you would basically go into people's during this 2-hour demonstration.
Oh, yeah.
You would take the Kirby and use all the attachments. And one of the things you would do is pull back their sheets and just start vacuuming up the mattress. And like you would have this filter on the attachment, and then you would show them, look at all of this nastiness that your vacuum cleaner has not picked up. Only the Kirby could get your mattresses so clean. It's literally like dead skin cells, freaking bed bugs. It was disgusting. Disgusting. I only did it a couple of times. You did that? That's how we were trained to do it. It was part of the presentation.
So they actually paid you, or you just did this for fun? Because I'm not sure.
The way it worked back then is they sold the vacuums for $2,000. Anything that you sold the vacuum for over $900 minus $2,000 would have been your commission. So if I sold it for $1,500, I get $600.
Damn, that's an expensive ass vacuum.
It was. Yeah. It fucking was, and that's back in 2000.
Shizzy Wiznut, thank you for the raid. Shizzy Wiznut, my friend, must have just finished his stream. It's funny because I actually set up my stream to raid to his when I was done, so now I can't do that.
Dishes.
Thank you, Shizzy. Anyways, do you need a vacuum? Omar's selling.
He still has them in the basement.
Be honest. How many vacuums do you own?
I personally have one in my office that I stole from my wife. And then I think that there's a vacuum here somewhere.
I think.
I was actually about to ask if you picked up your wife while you were selling Kirby vacuums.
Oh no, but there's some pervy old ladies on that Columbus route, man. I'll tell you.
Oh, all right.
Over Worcester County, Ohio, man. It was a trip.
Did you say Worcester or Rooster?
Worcester,
Ohio.
By the way, do not get a speeding ticket in Worcester County because it's an automatic court appearance. You don't just pay a traffic ticket. It was like, no, you're going to appear in court, automatic 30-day license suspension. It's like, seriously?
Dude,
Jesus.
That I was just talking about it. Mine was in Cincinnati, and that's exactly what happened to me. I had
Yeah,
to show up in court.
they do not play over there in Ohio, man.
Oh.
I haven't been to Ohio in a long time, but I'll next time I'm there, I'm going to visit Worcester County.
Not much there.
I'm sure it's enough for me.
Well,
All right.
I
Anyways,
want us to use all the attachments.
There's a place in Ashland, Ohio, that's called Grandpa's Cheese Barn. And if you ever find yourself there, it's exit 186
That doesn't
Uh,
sound like a trap at all.
on 70. You gotta go. It's
I
so
haven't
good.
seen it, but I kind of want to.
It's great.
The biggest
Okay.
thing about Ohio is Skyline Chili, man. That place
Got
is
Columbus folks in the chat.
magical.
Is Columbus close
man.
to Worcester?
No, Worcester's like about an hour outside of Columbus,
That's not too far, yeah.
but that was my sales territory. We're going there and some other really rural places. I saw fireflies for the first time. It was a trip, man.
Oh, Shizzy's sending bacon. I love bacon. Thank you, Shizzy. You're my best friend. You saw fireflies? You said?
Fireflies?
I heard fireflies.
Omar, are you there?
Oh, yeah. I'm still here. I muted myself.
Sir.
I was coughing.
Okay.
Yeah, there were fireflies or
Hey,
lightning
Maureen.
bugs. They call them lightning bugs over there. But they're
Lightning bug.
basically fireflies. What's the difference?
Dude, Worcester is 21 minutes from Grandpa's Cheese Barn.
Really?
Yep.
How far is it from Columbus? About an hour and a half?
Which one? Grandpa's Cheese Barn?
I don't know.
Taking a road trip.
Worcester was at the courthouse.
It's an hour and 13 from Columbus, between Columbus and Cleveland.
Yeah, that sounds about right.
So, by the way, people who are coming in, this reminds me that What the Hales case that I was supposed to film on February 5th. There are 2 hearings I was supposed to film on February 5th. One of them is actually by Zoom. That hearing, I'm sure you guys know from listening to Shizzy's channel and everyone else's that it was postponed to April. I should still be able to film because I don't travel again until the end of May, but it'll be later than we expected because it was going to be this coming week.
No, you're going to set that up and you're going to end up with like 20,000 subscribers.
I don't know, man, because I haven't been I really haven't covered the case much at all. Like I have a couple streams about it. That's it.
But you're going to be the media outlet. Nobody else is filming, I'm sure. It's not on TBS News.
I mean, yeah, that's true. I'll be giving the footage to anyone who asks though, because I'm the pool camera like I was for the Clayton and Laura trial. So, but yeah, no, we'll see. Hopefully I'll be able to live stream it, but I don't know. And then I don't know much about the federal case with the Hale stuff, so I'm only filming the state cases. You can't bring the cameras in
I don't
federal
know shit
court,
about
so.
the Hales case. Although that guy did try to contact me once.
Oh yeah, he's been emailing me back and forth. Bruce, the lawyer.
Really? Emailed me
yeah.
once. I didn't even respond. Like, yeah, fuck all of that. I'm not even getting involved.
Yeah, no, Bruce has emailed me back and forth a couple times. I haven't had any problems with him or anything like that. I don't know what he's talking about a lot of the time. I'm just honest. I'm like, Bruce, I don't know what this is about. I don't know what you're talking about. So, and I'm really apologetic. I'm like, dude, I'm so sorry. I just really have no idea what you're talking about. Like, I'm so busy, but we did. We briefly talked about maybe having a phone call, but I was just kind of like, maybe after the state case is over and I want to catch up on a federal case, that'd be a good idea, but we'll see. So,
well, that's more reasonable than Gingras ever was.
Yeah.
Although I've heard other things about that guy that I know nothing about, so who knows?
Yeah, I mean, obviously I've heard stuff, but I sort of treat everybody like equal until if they do something to piss me off, then I'll be like, okay, we have a problem now. But even if somebody's like, I've heard somebody's a little crazy, people say stuff about me too, so I'm just kind of like, all right, I'm gonna treat everybody the same until I see otherwise, pretty much. Which has not always worked in my favor, but here we are. So sometimes it does. All right. Okay, this leads to the third. We're back to the filing, by the way. I'm not talking about Kirby anymore. This leads to the third and perhaps biggest problem with Clayton's argument. It ultimately does not matter whether fees were awarded under Rule 26 or some other authority, such as the court's inherent authority. That was precisely the point of cases cited in Laura's opening brief, like Radcliffe v. Rainbow. And we're skipping over this stuff because we're going to talk about the legal cases and stuff in our multi-stream with Omar. Let's see. On page 25 of his response, Clayton argues for that result. In support, Clayton cites, what does this mean, dicta? Clayton cites dicta.
Dicta.
I don't know. Is Omar vacuuming his lungs? What's happening here? I don't know what's happening.
Formal pronouncement from an authoritative source.
Thank you.
Legal
Merci beaucoup. Did I get that right? That's Spanish.
Yep. Yeah, dicta is a legal term that refers to a comment or observation made by a judge in a case that is not necessary to the outcome. The term is short for the Latin phrase obiter dictum, which means something said in passing. Obiter dictum.
Panda Bear 90 Blue Rose, they even sued DUI guy plus along for using her picture in the thumbnail. So yes, that was actually the case I was supposed to go film, and they have a motion for sanctions pending in that case, which is what I'm going to film in April, I guess now. So apparently the lawyer involved with the other party has to have eye surgery, and that's the story with that. So, all right, let's. Yeah, I don't know any. I've never spoken to or really heard about the guy at all, so I don't know anything about that. Except for that it was moved because I was supposed to be there, so I have to talk to the court. Okay, so this is talking about Karen Cheney, the site that not the case that Clayton cites. And it says Karen Cheney involves a vexatious litigant who filed multiple lawsuits trying to avoid foreclosure on her home. In the fourth such case, Ms. Karen Cheney was represented by attorney Gregory Lay. Is that how you say that? Lay. One of the defendants, a trustee named Martin Lee, was dismissed from the case for reasons not explained in the decision. 2 months after Mr. Lee was dismissed from the case, he served Ms. Karen Cheney's attorney with draft Rule 11 motion and a letter warning that the motion would be filed with a district court after 30 days unless the issue was resolved to the firm's satisfaction.
Am I the only one who's thinking of Mara Cheney?
No, me too. That's why I keep getting tripped up. I'm like, wait, what?
Karen Cheney, Mara Cheney.
Yep. Okay. So we're going to skip over some of this legal stuff because, like I said, we're going to multicast with Omar later. If not tomorrow, then probably some other time soon, to go over the legalese type of stuff that he can explain to us because we cannot do that by ourselves. And Omar's busy coughing right now. So, okay. And so David writes here, okay, right. So what's wrong with that? Clayton sees these scenarios as conflicting, but clearly they are not.
I didn't know I was muted the whole time.
Dude, wait, what? Really?
I was saying stuff the whole time.
No, dude, you weren't. You weren't saying anything.
I was explaining what dicta meant, and then it was like, "Oh, everyone's just going to talk over me." Then, okay.
No, you didn't. I did before you got here. I did the same thing for like a minute, and she just kept talking and reading, and I was like, "Okay."
And I was like, "Why is she?" And it was like, "Why is Lauren so quiet?" I guess I'll keep reading.
Karen Carson, thank you for the $5. I think that was the first Karen, but not the last. Oh, Karen. You're the only Karen for me. How about that?
I've never dated a Karen.
I haven't either, but
I'm not on the Karen boat.
My options are still open. Let's put it that way.
Yeah, there's nothing wrong with having your options open as long as they're not open when you're like 80. Because then you're like your probability pool.
Your mom 5977, probably a stupid question. Can someone please provide me with Lauren's email address? Also, I have had a Kirby salesman knocking on my door in the past. Was it Omar? Number one. Number two, if you want my email, you can ask Bruce Matzkin. We have emailed back and forth. And number three, here's my email here as I'm going to put it in the chat right here. It's just my YouTube email, so I will check it once.
Man, I got a lot of Kirby stories, man. I really do.
I'm going to hear that.
I was going to say, have you guys heard of the rainbow vacuum?
The fuck is that?
I feel like I should have heard of that. Is that
like this very similar kind of thing where they come into your house and they do like the whole demonstration and show you all the attachments, but it's on your carpet instead of your bed. So they'll show you like how nasty your carpet is. And as a kid, I remember this girl who was probably like 20 years old coming in and like doing this demonstration. She had no idea what she was doing. And my mom bought the vacuum cleaner. She bought it.
Oh my god.
So yeah, we were like, ugh.
Can we have a Kirby story stream? You know what? One day we're gonna do a stream called Survivors of MLMs. And we're gonna get Omar in there.
Coincidentally, when I was in Ohio, the only job offers I ever got were from MLMs. Someone wanted me to sell knives. I was selling
We've
like
seen the
toys.
picture. Hang on. Look at this. Look at this man right there. My picture right there. That is this man. At age
Look
20.
at that.
What were you doing that was excluding you from like modeling jobs? Seriously, what
Well,
did you do?
I
I
know.
went from being like a intern at a hip hop magazine journalist thing to going to Ohio selling Kirby's. It's like, oh, that's why everyone wants to come to LA. I get it now.
Are you going to tell everyone what your other job was?
In Ohio? Let me see. In Ohio, I worked as a telemarketer selling the Columbus Dispatch. I worked for a company called True Green Chem Lawn, aerating lawns. I worked as a personal trainer, salesman / whatever at 24-Hour Fitness. I sold Kirby's. I sold toys to businesses door to door. I sold coupon booklets, and like they would advertise them like in the newspaper because you would look in the newspaper for jobs. Hey, this is a sports marketing opportunity. Great. And then you get there and then they're literally having like this big meeting like they would MLM style, the big pep talk. Go out there, lots of energy, wear your suit and everything. And then they give you your product and you're selling these $500 coupons, booklets, door to door.
Oh, not the booklets. Okay.
I was like, oh. See, now that one, I was only there for like, you know what? I was there for a day. He's like, fuck this. I can't. I'm not doing it, man. Sorry, I can't. The toys one, I think I told her I quit like at lunch. Like, you know what? No disrespect or anything, but I can't, man. Fuck this. I'm out. I can't do this shit.
I feel like I want to do a sketch where I'm out there like trying to sell old school MLM stuff to people. Like stuff that wouldn't be around anymore. Like just see what they
about
say.
like a really old
Bowling
blender?
cards?
Yeah, that'll work.
I remember back in the day, they used to sell like you could buy into electric companies, and they were trying to say that you could own a monopoly with these utility companies because right now it's all SCE and whoever and whatever. But in 2015, it's going to be all these things. If you get in from the ground up, you can be rich beyond your wildest dreams. That kind of stuff. They said all kinds of crazy shit in the 90s, man. It was a wild time to be alive.
Anyways, back to the filing we were reading before we got caught up with vacuums and shit. All right. Okay, so what's wrong with that? Clayton sees these scenarios as conflicting, but clearly they are not. Any litigant who thinks the opposing party has violated Rule 11/26 has a choice. They can A, send an immediate notice threatening sanctions and hope the opposing party responds by dismissing the case, as Laura did here. Or B, they can wait, litigate the case, win, and then seek fees under any available authority. Here, Clayton took neither approach, at least not exactly. Instead, he allowed the case to languish for over 4 months to the point it was set for administrative dismissal due to inactivity. Then once the case was already functionally dead, he retained counsel who threatened Laura with retroactive sanctions. I mean, how functionally dead was it when she had not yet faked her miscarriage? I mean, wasn't it just like kind of in limbo pending still? Like,
it doesn't matter.
Yeah.
I mean, when stuff gets set for administrative dismissal, it's an automatic thing.
Mm-hmm.
And so maybe there was pending litigation, but there's also a baby yet to be ascertained. And so in August is when they filed the petition. In November is when they reveal a miscarriage. A couple of months later, there's new counsel where we're discussing sanctions and other motions, different things. She tried to dismiss. Clayton wants sanctions. He hires counsel. What point did Woodnick come in?
He was there in December, I think.
So then he was there right after the announcement of the miscarriage?
Well, she didn't announce the miscarriage until like later in December or January.
Okay.
And claimed that it had happened before.
Well,
So
she
then-
claimed it happened before, and then she claimed it happened before, and then it's somewhere in between.
And then, between
Usually-
before and before.
If you're requesting sanctions or any kind of similar remedy, the marker is when you should have reasonably known that you were due for sanctions. At this point, Clayton had asked for sanctions from the very beginning. But second, once it became clear there was going to be no baby, he was emboldened. He had new information, needed to be litigated. And usually, in order for something to get I don't know how it works in Arizona, admittedly, but in California, they'll let cases sit there for like 2, 3, 4 years.
Damn.
Before they just start dismissing cases like that. And so I didn't even know that was ever an issue in this case. I never saw that on the docket anywhere, but I haven't looked at it in a while. Who knows?
I mean, and that's why Clayton wanted to he didn't want this just to fall by the wayside, because then he would be the next TEDx video, the next
Right, of course.
for the sole entry.
The
Obviously,
Bachelor, ARPed me or whatever, and I got pregnant with
right,
twins. Yeah.
exactly, and who knows exactly what she would have claimed.
And
Exactly. Yeah, no, that would have been crazy. Like, she could have gone crazy lengths with that one.
One thing Jingers had told me was that Clayton could have still pursued whatever he wanted to pursue in a civil case, but he also didn't have to. Like, if he knew he had that remedy, he had that remedy, but he was still in an open family law case.
Right.
And maybe he didn't want to go after whatever for the civil, file a brand new lawsuit, go through the whole federal civil procedure, whatever. Just, we're here in family law court. The judge who heard the original petition will be the one that will rule on the sanctions, knows the entire case. There's benefits, there's pros and cons. He chose to stay here in family court. There's nothing wrong with that.
Right.
And so,
and if he started a new case, she'd be in his life that much longer, and he wants nothing to do with her.
man, I'll tell you what, in California right now, if you file a lawsuit, you're not getting a trial for like 4 years. That's about the timeline that we're dealing with right now.
That's crazy.
At least in LA County.
There are so many.
There's just a huge backlog. I don't know why there's a backlog, but it got worse after COVID and it just never really recovered. Some cases are quicker than others. But I literally have cases that I've been litigating since 2019, and we haven't even set trial dates yet.
My God. That's crazy.
And so it is what it is, man. Jingers' point. What is his point anyway?
Not sure.
I thought that like he's rehashing stuff that he's already said. I need him to better concentrate his arguments, because this is stuff we've already heard.
It's so
Maybe
much
it gets better.
So much of this is pointless, and he's even saying that it's pointless, yet he's continuing to explain all of the things he says are pointless. Why?
Well, it's like they say, brevity is the soul of wits. To which
who says that? I've never heard that before.
Like they
I think that's a Hemingway thing.
It's like, who the fuck said that? And what were they smoking?
Whale.
Brevity is the soul of wit. Who said it? It's a proverb that has gone unclaimed, I guess. The internet has failed me.
William Shakespeare.
Oh, fucking Shakespeare.
From Hamlet.
That's who it was.
From Act 2, Scene 2.
Huh. All right, then.
Look at
Erica says sounds like a Bruce proverb.
I definitely didn't Google that, guys.
Yeah, sure.
I knew it.
Schnitzel's on the ball with that Google.
I figured you were busy Googling French words or something.
You know what the French word for clown is? Clown.
Clown.
That sounds too close to some kind of derogatory word for pussy.
What?
Oh yeah, so just say pussy. That's fine.
I try to take the life out of
It's
my
a
word.
derogatory word for already kind of bad word. Okay, oh god. All right.
I was on
It's shat. A shat. Shat is the word for the slang for pussy, the C word, fanny, the T word. Shat.
the T word.
Shat.
Oh, y'all are going down a hole I'm not ready to go down. All right.
Oh, that's what he said.
I knew you were going to say that too. I set you up for that one.
Thank you.
B. Davis, what did I walk into? A hole that I'm not ready to go down. Anyways, here Clayton took neither approach, at least not exactly. Instead, he allowed the case to languish for over 4 months, to the point it was set for administrative dismissal due to inactivity. Then, once the case was already functionally dead, he retained counsel who threatened Laura with retroactive sanctions, a la Karen Genie. I hate that. No, I hate that word now. In response, Laura immediately moved to drop her petition, which by then was moot. Clayton inexplicably opposed this, putting Laura in a position where she was given no chance to remedy the sanctionable conduct and avoid the sanction. What do you mean inexplicably opposed?
Pushing back. It's not inexplicable. He got dragged into a parenting petition for a pregnancy that didn't exist. That was confirmed to not have existed. And he had suspicions that she was faking it the whole time. He had every right to go for the sanctions he was going after. When you file a frivolous petition and then the other party responds, you don't just get to unilaterally dismiss. And Jingers is not arguing that, but for him to call it inexplicable is just it's fluff. It means nothing.
Yep. So I have a question for you, Omar. As far as pardon me, as far as lawyers are concerned, like I know that you have to represent your client, even if maybe you don't believe your client. And then I don't know, whatever is attorney-client privilege versus them flat out like telling you that they did the thing. I don't know. But so you have to represent your client to the best of your ability. So, but then there's like going overboard.
Well, you can't suborn perjury. And so when you hear an attorney say, look, if you whatever you did, I don't want to know. Because I got to defend you. If you're going to tell me that you did this shit, I can't represent you. And so if he knows for a fact that she faked stuff, then he can't just stand by and let her testify that she didn't fake stuff. Because he's now suborning perjury. You could lose your license for that.
But if he thought she did and she never said that, that's fine.
Well, yeah, you can speculate. If you don't know for sure, look, it doesn't matter what I think. She's saying she didn't do it. And so I'm advocating for her. I'm letting her get on the witness stand. Other people are going to be the judge of whether or not she's credible or not. There's nothing wrong with that.
And so like, I guess in that realm, how I personally feel like he's just gone like way overboard from where he needed to go with this whole thing and representing her to the best of his ability.
Yeah.
What are your opinions on that?
Well, I think you know my opinions on that. But, yeah, I think that it's been well documented that his level of involvement in this case is unprecedented. It's not what you would see from a professional attorney that is well versed in PR strategies in a case. Usually the strategy in a PR campaign is to try to flip public opinion in your client's favor. And if that was his goal, he failed so spectacularly. I've never seen it like that bad, where it's like 99-1. I have yet to see a Laura Owens supporter, not just supporter of her, a supporter of his legal positions. Every attorney that I've heard speak on this case is in disagreement, but he frames it as if it's like it's this 50-50 thing. You're either this or you're that. And there's people that think things on both sides. And maybe that's true. Maybe there really are people that are in agreement with his position. He makes some good points, but the hoops that he has to jump through to make his arguments, although creative, fall flat because there's missing pieces. They don't logically connect. They don't
Look at
work.
me, Daddy. I'm a real gymnast now. Jumping through hoops.
Jumping through hoops, clarifying.
And so in sum, he's done a number of other things over the course of the last 8 months now. I don't know if he believes that his license is in peril, but he's been the subject of however many number of bar complaints. I don't know what's going to come of that.
Was
maybe
it seven?
Nothing.
7 or something like that?
I have not counted. I don't know what it is, but maybe nothing comes of it. Maybe he gets his license suspended. I don't know. All I know is if it were me, I would have done things different. Is all I could say.
And he called Woodnick the most unethical lawyer he's ever encountered. That's so random. That is so random. Like the guy really didn't do anything wrong. They just have differing positions, as you do in a legal case.
It tracks with his disposition, because I know Gingras to be an acquirer of things. He tries to get you in his pocket. He tries to be friendly and be your friend. And the second you realize it's not going to happen,
he turns on you.
Is that it? When you realize it's not going to happen, you're dead to him?
Yeah, and then all of a sudden I'm the enemy, so I'm dead to him. Woodnick, obviously, on the other side, he tried to be professional. Now he's the most unethical lawyer he's ever seen. This guy, Marcus, he says in the video that I watched, oh, he's real professional, but there was some pushback, and that's okay. I feel like in like a week or two, Marcus is going to be dead to him too.
Yeah, once they have oral arguments, Marcus is going to be dead to him.
Do you think it'll go to oral arguments, or will they just rule in writing?
Why not? If I can do the oral argument, what's the big deal? I'd be surprised if it wouldn't go to oral arguments.
Apparently, they approve them like fairly frequently.
Yeah,
Okay.
There's no reason not to have oral argument. Why not?
That's what he said.
I was waiting for that. All right. This is where the heart of the procedural error lies. Had the law been followed correctly, the trial court would have granted Laura's dismissal request on December 28th, gave her the absolute right to invoke the safe harbor in response to a threat. that would have terminated the case before either party incurred any significant fees. That outcome is exactly the result Rule 26 was written to achieve. Wasn't Rule 26 wasn't the most unethical lawyer he's ever seen on the committee that formed Rule 26 or something like
he
that?
authored it. He wrote the freaking rule.
And okay.
Knows how it works.
But which was not achieved here solely based on Clayton's, is it dilatory invocation of the rule and the trial court's erroneous refusal to apply the rule correctly. Instead of granting Laura the safe harbor to which she was entitled, the trial judge erred by rejecting Laura's attempt to drop her petition. This is a lot tamer than I thought it would be, to be honest.
Well, you can only be so sassy in appellate briefs.
I mean, you could have put out for the last filing. I mean, come on.
his big closing salvo. Hey, Gingras did say like he wants to retire in the next 3 years or so, move to Europe. So like he just doesn't give a fuck. It explains a whole lot. It explains a lot.
Also, I just want to call out that on one of your streams, Lauren, I said he is going to quit. He's going to retire soon and move to Europe. I said that.
They're gonna let him move to Europe.
I respect that move, man. Good for him.
Yeah. All right. Let's see. Instead of granting the safe harbor, the trial judge erred by rejecting her attempt to drop her petition. The court then further erred by forcing Laura to involuntarily litigate the case, ultimately ordering her to pay $150,000 for acting unreasonably by filing the case without a sufficient basis, and B, by continuing to litigate the case against her will. Yep. Here, there is nothing unfair or inappropriate about a rule which gives a party accused of misconduct the option, indeed the unconditional right, to stop that conduct.
Read that sentence again. What the fuck is he on about?
Here, there is nothing unfair or inappropriate about a rule which gives a party accused of misconduct the option to stop that conduct. She hasn't stopped the conduct, by the way.
But that's not
there's not even a rule that says that.
The issue is not whether or not it's unfair or inappropriate. The issue is literally whether or not the invocation of that rule eliminates all other rules. To me, that's the issue. I don't know what he's on about here, but you know.
Yeah. Malin Lindstedt. Good morning, Miss Lauren, with guest from a very cold Sweden. Good morning. I wish you a great weekend, and no, we don't want him in Europe. Well, it's settled. He will not be moving to Europe.
At least not your town.
It has to be unanimous. All right. Okay. The problem here. Did I miss something? Rules 1126 were adopted for the express purpose of permitting litigants to drop claims without facing sanctions, no matter how egregious the violation. Is that true?
I gotta read it again. You said
rules.
It's like the last time when she would ask your opinion, you're like, huh?
No, it's fair. I do that to him all the time on his stream. He'll be like, Lauren, what do you think? I'm like, what are you talking about?
And then she's like eating beef or something.
I wasn't eating beef.
What?
Or like, well, last time she was like,
hot dog?
I'm getting my stream. No, she had like a steak, shorter steak.
Oh,
and she was eating gravy off of it or something.
No, I wasn't eating gravy off it. I picked up the steak and I was eating it like
with
this, like a turkey leg.
You were in Australia, weren't you?
No, I was in Tennessee, and you were there.
Oh, well, not with you.
No, but you were on the stream when I was doing it.
But I thought you were in Australia for some reason. You ate something in Australia.
I ate a lot of things in Australia.
On the stream.
Oh my god.
Yeah, I don't remember. I'm sure I did. I just don't remember what it was. Yeah.
Steak fingers, Stephanie says.
Steak fingers. No salad fingers here.
All right. So he says that is exactly what the rule was intended to encourage. Rules 1126 were adopted for the express purpose of permitting litigants to drop claims without sanctions, no matter how egregious the violation. That's great and good for you. And that's correct. That's why they were adopted. The point is, who gives a fuck? That was not the rule that was issued in this case. Just tell me where the invocation of Rule 26 supersedes Rule 25 and Rule 11. And then I'll agree with him. Until I see a case that says that, or any authority that says that other than him, then this is a losing appellate brief. In my eyes, anyway.
Mm-hmm. And do you see any good reason for it to supersede, or whatever the right word is, these other rules?
Huh?
Omar.
I don't know if you
He's
left
like,
this or not.
fuck that question.
Bye. Anyways, until our friend is back, the problem here, aside from the fact that Clayton should have invoked Rule 26 4 months earlier, as the trial court refused to allow Laura to take the safe harbor, the court then punished Laura severely for continuing to litigate the case, even though she was forced to do so against her will. Serves her right for all the time she forced innocent men into court, but okay.
Yep.
Even if that did happen, which it didn't. All right, this is exactly the wasteful, absurd result Rule 26 was designed to prevent. Well, I don't know. Why didn't you ask one of the guys who wrote it? He's litigating for the other side. The trial court's refusal to grant Laura the safe harbor was a pure error of law. That error standing alone requires reversal of the judgment below. This court should therefore remand with instructions to dismiss the case with prejudice without regard to any other issues. Issue 2, structural error. Let's assume this court rejects Laura's Rule 26 arguments. Further assume the court finds the safe harbor of Rule 26 does not affect the trial court's ability to award fees under other authorities. Does that mean the $150,000 judgment in Clayton's favor may be affirmed? Absolutely not. All right. Laura alleges the trial judge violated her constitutional right to due process by performing a secret, undisclosed investigation into the facts. This is so dramatic for like a simple fact of Planned Parenthood business hours.
It's like the opening of his brief, like a telenovela.
Yeah. Omar says my Roadcaster rebooted itself. Okay, well.
Uh-huh.
All right. Does that mean the 100? Okay, absolutely not. Laura alleges this trial judge violated her constitutional right. Blah, blah, blah. We got there. This resulted in the court making a key finding that Planned Parenthood is closed on Sunday, which was supported by no admitted trial evidence. How key was that finding? I feel like it was not that key.
No.
But okay. Laura argues these facts constitute structural error because they prove the trial judge was biased.
He has no evidence that she investigated it herself.
Right.
He has zero evidence of that.
No,
and
let's harp on it anyways.
Maybe that's going to open this motherfucker up to a defamation case.
I don't know. Okay. They prove the trial judge was biased as shown by the judge's decision to engage in unlawful conduct, which violated Laura's right to due process. Laura further claims the only available remedy for this violation is automatic reversal of the judgment and a new trial before a different judge. Well, that didn't work out, did it? Bearing in mind, Laura also maintains there is nothing left to try here. Well, which... Understandably, Clayton challenges each point except the main one, that the trial court's finding about Planned Parenthood's business hours was not supported by any admitted trial evidence. Clayton calls this a harmless error, and he argues the issues of Planned Parenthood's business hours was cumulative and thus unimportant. He also suggests that even though the trial court never claimed it took judicial notice of Planned Parenthood's business hours, it could hypothetically have done so. Laura firmly disagrees with every aspect of Clayton's response. Well, of course. Structural error applies in family court. To begin, Clayton argues structural error does not apply in Arizona family courts because counsel cannot find any example of Arizona courts applying structural error analysis in a family law case. Laura agrees this is a question of first impression, at least in family court, and for good reason. Serious acts of judicial misconduct, such as occurred in this case, are thankfully rare in Arizona, especially in family court. Okay, all right. But as this case shows, judicial misconduct does happen. And as Laura explained in her opening brief and other pleadings, many other courts agree any independent factual investigation by a trial judge is unlawful, shows bias, and it constitutes structural error as a matter of law. The U.S. Supreme Court has limited structural errors to the following, and we're going to get more into that, guys, when we do our stream with Omar where we get into the legal stuff. Laura does not dispute that it appears no published, or unpublished, Arizona opinions have considered the question of whether structural error analysis applies in family court. Clayton suggests otherwise, claiming something similar occurred in Black v. Black, which he calls extremely instructive to the point the relevance of Black is difficult to overstate. There are two reasons why Black is not remotely helpful. And again, this is getting into the legal stuff that Omar is going to help us with, which we'll do soon. The second reason Black is not helpful is it appears...
All right, I'm back. I'm sorry. I was...
Okay, good.
What I miss?
Wow, I don't know. We're just continuing to read stuff.
Oh.
The second reason Black is not helpful is it appears Clayton misstates the facts of that case. Specifically, Black involved a petition to change custody of 2 minor children. So again, we're going to go over these cases with Omar in a stream. When are we going to do that?
Shit, I don't know. We
Up to you, man.
Well, what time are you available tomorrow?
I'll be around after like 5:30 Eastern.
I'm doing flat at 5.
Okay.
And
8 Eastern.
Yeah, 8 Eastern.
Hmm.
And I was doing a podcast starting tomorrow at 6 Eastern.
Mm-hmm.
Maybe that could be the one. I don't know.
Yeah. Well, just let me
But
know.
then it'd be limited to like 2 hours, and I'm not sure if that's going to cover it.
I mean, this really isn't too long compared to some of the other stuff. 45. But some of it's, like the footnotes and the intro and stuff like that. So, all right. Clayton appears to have invented these facts from thin air. Nothing in black says the trial judge investigated material facts without notice to the parties. Okay, so again, we're going to go over that legal stuff with Omar tomorrow or later than that. I don't know. Here, Laura agrees she did not stipulate to allow the trial judge to secretly scroll through social media posts after the trial. Again, like assuming social media posts are the only way to know Planned Parenthood was closed on Sunday, but okay. And then make factual findings based solely on these posts while discussing the case with her father. Not the father again. In that regard, this case is marginally similar to Black. Okay. But unlike in Black, the trial judge's horrific misconduct. Really? Horrific misconduct. Okay.
Well, it's because he ruled against him a lot. That's why.
Yeah.
She ruled against him a lot. That's why.
It was literally every time. But yeah, okay. The trial judge's horrific misconduct in this case is not subject to harmless error review. The misconduct was structural in every sense because it completely deprived Laura of her fundamental right to a fair hearing before an unbiased judge. While this question is a matter of first impression for Arizona, the issue is hardly novel. And then we're talking about Kentucky stuff. Yeah, we're going to skip that because we're going to talk about that more with you later. Kentucky Supreme Court opinion. Okay. In this one,
he's arguing that Arizona has never dealt with this issue, and here's how other states have dealt with it. It's supposed to be persuasive, but not binding. That's all.
Right. Notably, the court reached the conclusion that even though the source of the trial judge's research was unknown, because as in this case, the judge failed to explain where the extrajudicial information came from, here, like in Marchese, the trial judge never disclosed the fact of her investigation, nor did she ever disclose the source of the knowledge gained. Okay. Clayton suggests this is no big deal because the trial court could have taken judicial notice of Planned Parenthood's business hours, contrary to an ABA formal opinion, which says exactly the opposite. The Marchese court rejected that argument because the judge failed to disclose the source of the information upon which she relied. The record fails to support that the information was obtained from a properly authenticated public record. The use of the information acquired by the judge from an unidentified source is simply an inappropriate use of extrajudicial evidence to guide a ruling in a matter. Okay. We're talking more about other courts here.
This is real repetitive. There's nothing being added to the discussion.
Yeah. Well, I mean, are they supposed to add more? I mean, I don't know.
The point of the reply to their reply is to raise issues that you didn't previously raise in your original brief to further focus in on the key issues of disputes. But here he's just repeating his original arguments.
Mm-hmm. Okay, so somebody tell me how this makes sense. Clayton's argument is half right and all wrong. How are you half right and all wrong? Like, was that supposed to sound like witty or something? Because, like,
yeah, I think so. That's just his style of right. Schnitzel's on one right now. I think Schnitzel might be on a gummy.
No, I've never done anything with pot, but I do need another bourbon.
All right. In both cases, the appellate courts did suggest a showing of prejudice is necessary, as would be true in harmless error review. So Clayton got that part right, but you said he was all wrong. I don't understand. All right. Anyways, if you make my voice go up like that, then you did something really dumb. But in both cases, the courts held any ex parte investigation by a judge is always unlawful and prejudicial if used to decide any fact in the case. Okay, we're going to, again, skip over some of this stuff. In short, the cases Clayton cites do not help his position. They destroy his only argument that a showing of separate prejudice still must be made in a case involved an unlawful judicial investigation into the facts. That is wrong. Okay.
What? Okay.
Oh man, Omar, did you see it says depriest?
Where does it say the priest? Highlight that for me. Oh, the priest. The priest.
You were almost a
Priest.
priest.
Okay, what the okay, pause. What the fuck is going on with this priest shit? Well, what were you a priest or were you not a priest? And
I was
why?
Not a priest.
But were you thinking about being a priest? Like, what was the deal there?
That is well, I've told this story in my other shows. I used to be a youth pastor and I got kicked out of church.
Okay.
Because of reasons.
You don't have
I
to
wouldn't do their bidding. And so I got kicked out and then I went and did the hip hop thing. And then I fucked off to Ohio. That was my story for a little bit.
I mean, whatever, man. You obviously ended up in a good place, so
It was my journey.
all right, let's see. Here, there's no dispute the trial court made a factual finding that Planned Parenthood is closed on Sunday. That was not supported by any evidence at trial. There's no dispute this issue was not discussed or mentioned at trial, but it was discussed in social media posts after trial. The only reasonable conclusion, that is not the only reason, okay, is the trial judge looked at social media after trial ended, and she then based her factual finding on those posts. Well, okay, again, the
He's
only
such
reasonable conclusion.
A little
Like,
fucking bitch.
Look, the thing is, she changed her story on the day of trial. And so, like, even if the judge had gone and done some independent research, it doesn't mean she looked at social media. She could have just gone and looked up Planned Parenthood hours. You know what I mean? Like,
there was some pushback on whether or not he or she had faked an ultrasound. What was he talking about? Where he was disagreeing with Marcus.
oh yeah, that's in the beginning.
About whether or not there was in the deposition that they had disagreed about, or she admitted something.
So the thing is, she admitted in her Judge Duty hearing, I can't remember the date off the top of my head, fall of 2023, that she had sent Clayton a video of an ultrasound claiming it was hers. So, but what Marcus says apparently is that she claimed this in her deposition and that she admitted it belonged to someone from 7 years prior.
Oh, I remember that.
Right, but she never explicitly said yes, and I stole that, and it didn't happen in the deposition. So that was what he had to bug up his ass about.
But did she need to say I stole it if it was somebody else's?
Exactly. He just said, I don't know what were the exact words. Did you send me an ultrasound video claiming it was yours?
So
maybe
semantics. What are we doing?
I know.
All right. Not structural error, dipshit. Is all I'm going to say to that.
This misconduct is per se structural error of the most obvious kind. Assuming this court agrees, automatic reversal of the judgment is mandatory without regard to prejudice.
I will say that Laura says that she had read this and was really happy with it and really impressed. David was really happy with himself. And I don't know, they thought they put something on the page here, but I'm reading and it's just repeating a bunch of stuff that he's already said. I'm seeing nothing new.
He said he put his heart and soul into it.
Yeah, well, maybe he did. So, hey, sometimes we just go out in the blaze of glory.
I don't know. I feel like a blaze of glory would have had more "Look at Me, Daddy" in it. You know what I mean?
I feel like he's more like the brown paper bag that gets left on your porch, and and it's caught on fire. The kids catch it on fire, and then it's actually a bag of shit.
He's raging against the dying of the light.
Raging ass Gingras.
Oh my God. All right. Issues 3 and 4. The court erred by awarding fees awarded under other authority. If Rule 26 is the centerpiece of Laura's argument, Clayton's centerpiece is this. Ignoring Rule 26, the court still could have awarded fees under other authority. That argument has superficial appeal, but it suffers from multiple fatal flaws. Flaw 1, Clayton never moved for fees under any of the authorities he cites. Is that true? I don't know if that's true. The docket is clear.
He doesn't have to, though. She can.
Right.
I know, but they're saying, but there was supposed to be a special hearing if you did it.
Okay. The docket is clear. The only fee-related motion Clayton never filed was his Rule 26 motion for sanctions. I kind of sworn they mentioned, other sanctions that the court deemed appropriate or whatever. So, whatever.
Yeah, I thought they did, and I thought she had also asked for them to.
Yeah. The rules of family law procedure require parties seeking relief to bring a motion for relief. Okay. Even if the trial court did not sanction Laura under Rule 26, she was still entitled to the safe harbor of Rule 26 by withdrawing her petition after Clayton's counsel threatened her.
No.
I mean,
God.
what was the threat exactly? The threat was what, we're going to continue with this in court. That's not a threat. You know what I mean? Like, it's making it sound like they did something terrible.
She and Gingras are just always the victim.
Yeah.
I
Well,
feel.
they're just making it sound like so like there was some sort of malicious intent or something. And it's
Right.
kind of ridiculous.
Right.
Like it's just like one party in the court case wanted to continue because he wanted his name cleared. Like, how is that? Like, oh my god, they threatened her. They threatened her, like she said ex parte to the judge in the other hearing, that she accused this lawyer of conspiring to have her sexually assaulted, which never happened. There was no evidence of that. And like the fact that even David, the way he plays that off is so ridiculous. Like, how could he actually see that, let that roll off his back and be like, yeah, I'm not gonna have any problems with this person?
Mm-hmm.
Like, holy shit. And then he really thinks people are insane for saying that he might have trouble with her down the line. Well, look at what he did to another attorney during a court case.
Exactly.
Like what she did, sorry. Not he. So yeah, I don't know. That's just nutty to me. I don't know if you remember exactly what it said. I think it was, she said the FBI was involved and whatever.
Right, that she had reported it to the FBI.
Yeah. No, that's ridiculous.
And let's see who threatened whom. Didn't she send him an email saying she was going to sue him for $1.4 million if he didn't drop the lawsuit?
I always forget about that one.
Just another topping thrown in there.
Yeah, I guess. I mean, what's another one? What's another one at that point? Okay, let's see. Laura unambiguously attempted to do exactly that when she moved to dismiss her petition. The trial court erred by refusing to permit Laura to withdraw her petition. Laura had an absolute right under Rule 26 to do exactly that.
And the judge had an absolute right to rule differently.
Right. Okay? At that time, Clayton had not incurred $150,000 in fees, and any fees he did incur in late December were unnecessary and unreasonable because a simple phone call from Clayton's counsel would have revealed Laura was no longer pregnant. That is not his responsibility.
No.
If she was no longer pregnant because of, if she had concerns of a miscarriage in July, they have claimed at some point, which that timeline has changed a lot. If it actually happened in July, as they claimed, she had a responsibility to deal with that right away.
Especially if she's trying to have him involved in a parental role in these children's lives. Why would you not tell him? Why would you, any reasonable, which we obviously know she fucking isn't, in my opinion, why would you not let that person know, hey, just want to let you know I had a miscarriage.
Right.
So this is all moot, just for you. And let's move on with our lives. But no, she didn't do that.
Nope. Yeah. And even if she had, if I were him, I wouldn't blame him for not believing her because holy shit, this whole thing was crazy.
Right. I mean, she has done everything to make everyone who doesn't believe her lose trust in her. It's all because of her actions and because of what she has said. It's not because of anyone else. And we're not just flat earthers. We're not brain.
You aren't?
Well, I mean, I actually am, but not in this case.
I'm a fat earther.
I'm a food earther. Yeah, it's just so dumb. All of it's just dumb.
Yeah.
Totally.
Yeah, hi, I'm just checking. Still pregnant? How are the twins?
Am I still going to be a daddy?
Yes, reasonably, he should have checked in with the woman who stalked him and messaged him from at least a dozen different phone numbers when he kept trying to block her. Reasonably, he obviously should have contacted her to continue asking if she was pregnant.
And reasonably, he should have paid his lawyer money to contact said person.
All right. Any fees he did incur in late December were unnecessary because a simple phone call would have revealed she was no longer pregnant, and thus there was no need for Clayton to defend the paternity allegation.
But that ignores Clayton's central thing, that it's not that he didn't know that she was pregnant. Mm-hmm. It's that he thought that she faked the pregnancy.
Right.
And so it wouldn't, good for you. You're not pregnant. I knew that shit. But now I want sanctions because he dragged me through this litigation for no reason. You were never pregnant, was the point. Again, missing the mark.
Yeah.
Exactly.
All right. This is where Clayton's position is so deeply confused. So let's try to let's try to finally put this to bed. Laura is not claiming Rule 26 is the only authority by which fees/sanctions may ever be awarded. By extension, she is not saying a person who violates Rule 26 could never be ordered to pay fees based on other authority. Oh, good. We're done then. Rather, Laura is simply saying that to award fees or sanctions under other authority, there must be a separate factual basis for such an award beyond just the Rule 26 violation.
Okay, but then first in time would matter then, right? So if he's bringing the sanctions under those other two statutes for the same reasons under Rule 26, but he raised those issues under the other sanctions statutes first, then wouldn't that, by his own logic, invalidate Rule 26? If we were to believe that, then
no, safe harbor.
No, fix the safe harbor.
Yeah, but I thought you could just say that word and it was fine.
Well, if I'm going by his logic, because the merits of the Rule 26 motion were exactly the same as the other two requested sanctions, then Rule 26 should have never been allowed to proceed anyway. Using that logic, am I wrong? I feel like that's what he's trying to say, but it just works in reverse. Then we have to figure out on what basis was the Rule 26 motions brought. And if it was exactly the same as the other two motions, then it stands to reason from what Jingles is saying here that the Rule 26 motion would have been facially moot.
Moot.
Because those, the merits of those, God damn it.
It rhymes with toot.
And a boot.
Because we are litigating those issues under the other statutes. I'm not making that argument, but that's his logic, and it doesn't make sense to me.
Wow. Okay, hang on. So he said here the deeply confused thing, and he's doubling down on that, the deep confusion on this point. Asshole. All right. Put differently, conduct that violates some other rule or supports a fee award under some other statute can always be addressed by the other rule/law, but a violation of Rule 26 resolved by invoking the rule safe harbor is not punishable under other authority without any other basis. Clayton's deep confusion on this point is best demonstrated by his discussion of Holgate v. Baldwin, which again, we're going to talk about that in our stream with Omar when we do that. Let's see. Clayton suggests this supports his position because in this case, the trial court did make a finding of bad faith. Problem solved, right? Wrong. Yeah. Almost a jinx. Like I said, we'll go over that some more in the stream where we talk about this legal stuff more in depth. Let's see. This is the crux of the problem when Laura moved to dismiss her petition on December 28th. Even if we accept Clayton's allegation that Laura violated Rule 26 by filing a petition she knew was groundless, we accept, yes. At that time, she had not engaged in any other unreasonable litigation conduct sufficient to support an award of fees under other authority. Okay. Clayton was not, okay, this is talking about mid-November. Oh, okay. On the contrary, from August 1st to the time Laura learned her pregnancy had failed in mid-November. Wait a minute. Okay. So they're saying she learned in mid-November. That's right. Okay. But they've changed the timeline of when she miscarried. So she learned of it.
But this is Jingles' style. Like if he were to write this paper in law school, this would be like a C. And it's not that he's a bad writer. It's just that most good writers that go to law school are shitty writers. The problem with his writing is that everything that he's saying is conclusory. He's just saying stuff. It was not unreasonable. Therefore, we should do this. Clayton was obviously wrong, and all these conclusory statements without factual evidence tying it all together. And so it makes what he's trying to do, it just falls flat.
It reminds me of a president we have right now.
Fuck yeah.
Lauren doesn't talk about politics on her stream.
Oh.
Anyways.
I didn't say president of what?
Shut up. All right.
President of
okay, hang on.
Christ of Latter-day Saints.
Well, that's scary. Anyways, Clayton was not represented by counsel in the paternity case in mid-November. He had incurred no fees defending that action. All that happened was Clayton took a DNA test, which was inconclusive. Wait, how many? We're inconclusive, David. And shortly thereafter, Laura learned the pregnancy had failed, and she basically abandoned the case. That's it. That's it.
Is
Really?
that how Ravgen
Little to no fetal DNA? I believe that was the
right, but what is that how they categorize it? Is the result little to no fetal DNA inconclusive? Is that how they categorize it?
Yeah, it's like she took a test, it was inconclusive, and that was it. No, she took multiple tests. One they claim was lost in transit, and 2 showed little to no fetal DNA. So
can you and they can't legally say
no
0 fetal DNA. They would be sued probably all the time.
Yeah. All right. Thus, this case is exactly like Holgate insofar as the only basis the trial court had to sanction Laura in late December was for violating Rule 26 at the time her petition was filed. But as of the period between August 1 and December 28th, Clayton does not allege Laura did anything to justify any award of fees, much less $150,000, under any authority other than Rule 26. This is like the same thing you said 4,000 times. All right. Flaw 3, again, is Holgate. Again, as in Holgate.
Flaw number 3. Have you seen something written like that in a filing, Omar?
Flaw. I've seen a lot worse. I haven't seen specifically that, but I've seen, I don't know, comparable bad writing before.
Okay.
Hyperbole. Flaw number 3. Yeah, I'm actually not that offended by flaw number 3. I'm offended by other stuff.
Let's see.
And actually, I'm not offended at all. I'm just, my law school mode is kicking in, and this is like losing points left and right. Come on, man. Get shit together.
Maybe he'd end up with a 69.
Nope. Let's move down here. Chapter 4, Article 1 involves legal decision-making and parenting time. And although Laura's original petition certainly asked the court to make future orders regarding parenting time, no such orders were ever made. It is undisputed no children were born, and nothing in Clayton's fee application suggests Clayton incurred even $1 in fees defending any parenting time issues. Okay. Similarly, the $150,000 award is not supportable under ARS 25-809G for one simple reason, because even if Laura acted unreasonably by filing her petition without medical evidence, as Clayton argued and the trial court found, this unreasonable conduct stopped once Laura received confirmation she was no longer pregnant in mid-November.
So before I even, because I'm about to jump off, I gotta go pick up my wife from the airport like in 5 minutes or so. But
don't text and drive. Okay,
no, I do voice messages when I can. But what I was looking for was some kind of reasoning for his stuff. I finally understand his logic why Chapter 25 sanctions were ineligible. I guess he's basing it on the fact that the merits of the Rule 25 sanctions were exactly the same as the Rule 26 sanctions, and therefore 26 should invalidate 25, without taking into consideration that the 25 sanction request was back in August, and the Rule 26 request would have been when? In 2024, in January, something like that. It came after. And so if that's the basis for it, if he's acknowledging finally that she was eligible to receive sanctions under Chapter 25, that's not the issue. It was this merit-based thing. Then it's solidified for me that he's going to lose this appeal. I have no more, I need no more clarification. If that's what he's going off of, then he's lost.
Jerry Mitchell says, wasn't the moon bump hearing in November? Was it November or October? I can't remember.
It was November.
November. Okay. So yes, it was. And then she was claiming that she had miscarried long before that, but also she was in court wearing a moon bump, but okay.
So does your belly keep growing when you have a miscarriage?
No.
I mean, I would think no. I have never asked like a professional, but
I have experienced a miscarriage before, and I didn't measure bellies or anything. But I mean, it was pretty much the same thing as when you have a baby, your body just kind of goes back to normal. That's what I remember happening. It certainly doesn't keep on growing, that's for sure. And if it did keep on growing, it'd probably be like cancer or something, or something else, a tumor.
Yeah, and the reason I say that is that it obviously, like so many things, it doesn't line up with the any timeline that she claims she had a miscarriage. If her belly is getting visibly bigger, yet she had already had a miscarriage, what was it? Just from food, or what? Like, what is she trying to show there?
What you guys are doing, what the people in the audience are doing, is they're attaching facts to their points, which Gingras is failing to do.
You can't do that.
No,
That's why he turned off his comments.
Conclusory.
Oh yeah, true.
Did he turn off the comments? Really?
On his last YouTube video, yeah.
Oh, poor guy.
He got upset that you weren't responding, so he just turned it
I
off.
don't think I've ever responded to anything comment-wise for Gingras other than to defend that he didn't like ambush me with Laura Owens.
Yeah. You did right by him, and he was a dick to you. I'm sorry.
Well,
Kimbo brings up a good point. Not from a baby, maybe from infection from retained fetal contents. So the doctor she went to when she found out she was no longer pregnant definitely would have checked for that. That would have been a thing.
And she
if
claims
her
that
stomach was that big.
And she claims that she passed fetal content.
Right. Right.
that's not painful.
Well, if you also like, you don't just text a hotline and call it a day. Like you could get an infection and die. Like
so
you're
dumb.
not going to do that.
Like she did that obviously just so she had like proof, quote unquote, that she like sought medical care, and that like she had made like like there's a medical document that said that she did that. So that's going to prove like what she's trying to claim. It's so dumb. Again, it's like Amber Heard. Who would not go to the doctor if you were graped with a broken glass bottle?
Right.
No, like you would go.
Especially if you go to the doctor for something very simple. Like you're fine going to the doctor for a simple pee test, but
for a broken
miscarriage,
for a broken foot on the black ice in San Francisco.
Right.
Hey, folks, I gotta go. I apologize.
Right. Thanks for joining.
See you later.
See you guys tomorrow.
Drive safe.
Okay.
All right. Bye-bye.
Bye.
All right. We don't have too much longer on this to go. Let's see. Yes, ideally, Laura might have moved for voluntary dismissal under Family Law Rule 46 sooner, but her failure to do so did not cause Clayton to incur any fees defending the paternity aspect of the proceeding. On the contrary, court administration issued a notice on December 4th setting the matter for dismissal due to inactivity. Laura did nothing further after that date to keep the case active. Therefore, because ARS 25809G only permits an award of fees reasonably incurred maintaining or defending a proceeding, because Clayton did not incur any reasonable fees defending Laura's petition prior to her withdrawing the petition, the $150,000 award cannot be sustained under 809G. Okay. Finally, the $150,000 award cannot be sustained under 25-415. That section authorizes fee awards for various things, but the only part Clayton invokes is 415A3, which applies to violations of a court order compelling discovery. Well,
right. he's trying to say she didn't have to compel what you were asking her.
Of course she had to. What the fuck do you mean? If a judge orders you to comply with something, you lie and avoid it. Like, what? Here, putting aside the fact Clayton never filed a motion seeking fees under 25-415, and thus no award under that section could be made, there was one order compelling discovery. Yeah. This order required Laura to produce 5 categories of information, but there is not a shred of evidence in the record showing that Laura failed to comply with this order. Yes, there is.
She didn't turn over her damn phone.
Well, no, that and like she didn't, send any records or produce a release. I don't think for Planned Parenthood LA, did she?
Exactly.
Which is where she, on the day of trial, changed her story to say she went to Planned Parenthood LA, which she never produced records from them or gave a release for those records to my knowledge. So, yeah, that's not complying with discovery. Okay. Instead, what Clayton seems to believe is that Laura had a general duty to disclose information under Rule 49 because she changed her story about the location of the Planned Parenthood location she visited. Let's just downplay that. All right. That change violated Rule 49 because Clayton believes Rule 49 required Laura to disclose that specific information prior to trial. No, the judge required her to.
And the judge said that Mike Maricini could be at trial.
All right. Well, he doesn't care about that.
Right.
Clayton's argument fails in multiple ways, only if you don't listen to what the court says, but that's fine. First, even assuming Laura was required to disclose something under Rule 49, she was, the failure to do so is not by itself punishable with fees. You're an asshole. Again, by its own terms, 25415A3 only permits fee awards when a litigant violates a court order compelling a court order compelling disclosure. What are you not getting, dude?
I feel like he's the what am I? When you go certain places or you're doing certain things and you see like very like specific rules about things that you have to comply with, and you're like, oh, like someone must have done that at some point in the past, and like that's why they had to add this rule. I feel like he is that person. He's the reason they rewrite. Lawyers like him are the reasons they rewrite these laws to be like extremely incredibly specific to like include like things like this so that people like him can't try to work their way around it.
I swear to God, it's like their argument. So often their arguments are like, well, you don't really have to do what the judge says. You don't really have to tell the truth. Like what the fuck?
Right.
How is that a winning argument? I don't know. I want to address this really quickly. Jerry Mitchell says the miscarriage supposedly happened in July, but she didn't know till November. She would have been dead from sepsis, in my 100% non-medical opinion. And I want to address that comment because these are like the horror stories you hear about in the media where like, and without saying anything about pro-choice, pro-life, whatever, there have been stories in the media regarding those debates where they like tell the story of people who were pregnant. They needed an abortion so that they wouldn't get sick, or they had a miscarriage and they needed, they needed the fetus out, or the fetal tissue out, and they couldn't get it in time, so they died. So yeah, it's a big deal if you don't get that taken care of. So yeah, absolutely, I believe she would have had a serious medical condition or possible death if she had, if the story happened the way she told it. It doesn't make sense. It is not reasonable. All right, let's see. Furthermore, Laura did not violate any disclosure duty under Rule 49. Nothing in that rule required her to disclose information about the specific... Yes, it did. About the specific Planned Parenthood location she visited. Clayton could have asked for that information and in an interrogatory under Rule 60, but never did. The judge said all records.
Exactly. They asked for all records.
Right. And she had to sign that in front of them, but she just like didn't tell them that she went there.
Right.
How is that okay? How are you being like, yeah, this was fine?
And it's like either he needs to go back to law school or not be a fucking lawyer anymore because it's terrible.
I don't know, man.
In
Rule
my
49,
opinion.
Does, of course, require parties to disclose the names, addresses, and telephone numbers of any witnesses whom the disclosing party expects to call at trial, but Laura did not plan to call any witnesses from Planned Parenthood at trial. Clayton did. The fact that Clayton wanted to call a witness did not require Laura to disclose that information under Rule 49. Nothing else in Rule 49 required Laura to disclose the type of information which Clayton claims was omitted. But again, fees cannot be awarded.
Also, why keep that secret until the day of trial? What would be her reason? Like if she did it for a genuine reason.
It's not that she kept the secret until the day of trial. It's that she hadn't invented it yet.
No, exactly. But I'm saying, like, what would be like an actual, like, aside from lying, what would be an actual good reason to keep that information? Why wouldn't you just disclose it up front?
Clayton and his lawyer conspired to have me assaulted and the FBI is involved. I don't know. Maybe she should have tried that one again. All right. Let's see. Issue 5, Laura is entitled to fees. Very little of Clayton's fee argument requires any response except for this. Clayton argues dismissal of Laura's petition would have been improper because his claims, including a determination about whether Laura was ever pregnant by him in the first place, still needed to be adjudicated. Yeah. This argument weighs heavily in favor of Laura's request for fees. Here's why. The question of whether Laura was ever pregnant by Clayton in the first place is clearly outside the limited scope of the family court's jurisdiction. This allegation is, if anything, an element of a civil abuse of process / malicious prosecution claim. Well, thank you for the idea, I guess. In other words, Clayton's description of his claims show the only claim he was seeking to resolve is one he knew or should have known the family court had no jurisdiction to decide. Nothing in Title 25 permits a family court to adjudicate civil tort claims like this. That fact alone and Clayton's otherwise unreasonable positions in this appeal warrant an award of fees to Laura. I can't believe
He
he's
needs to
called Clayton's
change. He needs
unreasonable.
to change. Wait, scroll up for a second. He needs to change. Award Clayton his fees costs
Hmm.
and remand this matter than true. Okay, you know what I'm trying to say.
Yeah, it's just 1 a.m. and I'm like, just say it. All right, so that wasn't
It's only 10 p.m. where I am.
that wasn't as like tedious as I thought it was going to be, just because we didn't really go over a lot of the legal stuff. I scrolled over because we are going to do that with Omar. Guys, I'll let you know when that's happening. I'm sure Omar will let you know as well. It'll be like a multicast, so we'll probably both be there, and I'm sure my friend Patrick might be there with us, the lawyer who has come on my stream a couple times. So everybody, appreciate you being here. Thank you for watching. If you could hit the like button for me if you haven't already, I would really appreciate it. It would help me out a lot. Please ignore her and hit the like button. Please don't let that sway your decision.
Look at my schnitzel picture and listen. Like us.
No, look at mine. Like us. I can't do it. Wait. Like us. No, I can't do it. I can't.
Like us.
That was terrifying. All right. Good night, everybody. See you next time.
Bye, guys.